Here we are again. In this subunit, we're going to discuss consequential damages. All right, to refresh our memories, these are the topics we said we were going to discuss in Unit 12. We've already discussed general damages. In this particular subunit, we're going to discuss consequential and incidental damages. We're also going to discuss liquidated damages. All right, let's talk about consequential damages, and to understand what they are, let's compare them to general damages. But first, to put the aggrieved party in as good a position she would have been had the contract been performed, we need to give the aggrieved party both general damages and consequential damages. The combination of the general damages and the consequential damages that will put the aggrieved party in as good a position she would have been had the contract been performed. So we've already talked about general damages, and general damages are about the lost benefit of the bargain because you breached this contract. There was some sort of benefit of a bargain, some sort of profit under this contract, and because you breached this contract, I lost out on that profit. The general damages that you have to pay me will be that lost profit. Well, consequential damages are slightly different. They do not measure the lost benefit of the bargain under our breach contract. They measure the lost benefit of the bargain based on from relationships with third parties. In other words, your breach under this contract has somehow adversely affected my relationship with third parties. So here's a simple example. I have a classic car that needs to be restored, and you restore classic cars for a living. I have a third party lined up to buy this car if it is restored. So I have a contract with a third party. I bring the car to you, I explain the situation to you, I ask you, can you restore this car? And you make me all sorts of promises about how this car is going to be so beautiful after you get the job done, et cetera, et cetera, et cetera. You understand that I have a contract with a third party to buy the restored car. We enter into a contract. You promise to restore the car. You breach that contract, right? So I'm entitled to general damages, which whatever the benefit of the bargain for me under this contract was, you have to pay me. But I'm also entitled to consequential damages. I would have made a profit by selling that restored car to the third party. And because you have not restored this car, I lose that profit. That profit, that is what we call consequential damages. To put me in as good a position I would have been had the contract been performed, not only do you need to pay me the benefit of the bargain, the general damages, the benefit of the bargain under this contract that you breached, you have to compensate me for the profit I lose because I cannot meet my contractual obligations with the third party. Let's look at another example. Let's look at this example. We have a contractor and a baker that enter into a contract. Contractor promises to renovate the bakery, and the bakery will be closed during the period of renovation. Contractor promises to finish the renovation by April 1st. Now, contractor breaches this contract. How does contractor breach this contract? Contractor does not install some equipment properly and fails to cure that breach. Baker has to go out and find someone else to reinstall the equipment. This costs Baker another $10,000. Because of contractor's breach, the bakery cannot reopen until April 25th. So let's look at the baker's general damages and the baker's consequential damages. What are the baker's general damages? What does contractor owe Baker as general damages? Well, it's the cost of remediation, that $10,000. You remember the fact pattern said that Baker had to go out and find someone else to fix the breach that contractor had committed. and that cost $10,000. So those are the general damages. But there are also consequential damages here. Baker could not reopen the bakery until April 25th. Contractor had promised to finish the renovations by April 1st. So we have a period of time from April 1st to April 24th where Baker can't make Baker can't make profits because the bakery is closed. To put the baker in as good a position she would have been had the contractor performed her promises as they were stated in the contract, we have to give her general damages of $10,000, and we have to give her the lost profits from April 1st to April 24th. Those lost profits are the consequential damages. All right, let's talk about whether an aggrieved party will be able to actually collect her consequential damages from the breaching party. Here's the law. An aggrieved party can collect consequential damages, entitled to consequential damages, if, number one, she can prove them with reasonable certainty. This is the same rule that we discussed when we discussed general damages. You also have to prove your general damages with reasonable certainty. Consequential damages, however, have another requirement. If you want to recover your consequential damages, you have to show that they were reasonably foreseeable to the breaching party at the time the breaching party entered into the contract. Now, sometimes students make a mistake and they say that the consequential damages have to be reasonably foreseeable to the breaching party when she breached the contract, and that is not the rule. The rule is that the consequential damages of the aggrieved party have to be reasonably foreseeable to the breaching party when the breaching party entered into the contract. And this is the idea. When you enter into a contract and you are talking about the contract price, which is either the price you're going to pay or the price you are asking the other party to pay, you're going to assess a lot of things. Your cost of performance or the market price of whatever services or goods you're buying. You're also going to assess your risk under this contract if you breach the contract. And if there's a risk that you're going to have to pay a lot of money to the aggrieved party if you breach this contract, you're going to charge a higher price if you're the seller or the service provider. Right? Or if you are the buyer or the service recipient, you're going to be willing to pay a lower price, right, to compensate you for that greater risk. So for me to adequately and efficiently assess whatever price I'm willing to pay for this contract or whatever price I'm willing to charge under this contract, depending on whether I am the seller or service provider or the buyer service recipient, I have to know, I have to be aware of what potential damages I might have to pay you if I breach the contract. So if I know that your business is going to be closed if I don't perform as promised and that you're going to lose profits and I'm going to be responsible for those lost profits, my risk is greater under this contract. So I'm going to charge you more for my services. Okay. So consequential damages and this rule about whether the aggrieved party can recover consequential damages is just about the efficient pricing of risk in the contract. All right, let's talk about incidental damages. Incidental damages, it's a pretty easy topic, so we'll only give a few examples. You should be able to understand the basics of incidental damages just from this brief discussion. So incidental damages are expenses incurred by the aggrieved party to address the other party's breach. So for example, if you breach the contract, I have to go out and find substitute performance. I might have to advertise to find that substitute performance. I might have to engage a broker to find that substitute performance. The cost of the advertisement and the cost of the broker, those are what we call incidental damages. Naturally, I am the aggrieved party, and to put me in as good a position I would have been had the contract been performed, you have to compensate me for these additional expenses. I would not have had these expenses had you not breached the contract. Storage and maintenance of goods or real estate under a contract for the sale of goods or the sale of real estate, this will also fall under incidental damages. So imagine that you are a buyer and I am a seller, and we enter into a contract where you promise to buy goods from me, you repudiate the contract, and so now I have all these goods here and I have to store them. The cost of storing those goods until I can find substitute performance, those are incidental damages. Same would be in the reverse. If I deliver these goods to you and they're non-conforming, and you say, seller, you have breached this contract, please come up and pick up your non-conforming goods. In the meantime, you have to store these goods, then the cost of storing those goods are incidental damages. I have to compensate you for those to put you in as good a position had I performed my contract as promised. If I had performed my contract as promised and I sent you conforming goods, you would not have incurred the additional expense of storing these non-conforming goods. Finally, in this subunit, let's talk about liquidated damages. Liquidated damages are just the damages the party agree to in the contract. Beforehand, before there's a breach, they agree what they will pay if they breach the contract. So I say, if I breach the contract, I will pay you X dollars. And in the contract, you say, if you breach the contract, you will pay me Y dollars. Well, what does liquidated mean? Liquidated means to make something uncertain certain. So to make something certain. And that's the whole idea of liquidated damages. If you breach the contract, it's unclear how much injury I will suffer. It is difficult for me to prove that injury. And so it would be difficult for us to assess general damages. Let's just agree to it in the contract. Let's make it certain. Here's an example. Imagine that we have an owner and a contractor, and they enter into a contract where the contractor is going to do a project for the owner. And of course, the contractor promises to finish on a certain date. What happens if the contractor is 1 day late, 2 days late, 3 days late? How do we assess the damages? How do we assess the injury that the owner will suffer for that 1 day late, 2 days? It's really kind of difficult. It's going to be uncertain. Well, let's liquidate it. Let's make it certain. So in the contract, contractor promises to pay $1,000 a day for every day late. These are liquidated damages. Now, what are the limits on liquidated damages? Well, first, the law says that the liquidated damages cannot be a penalty, right? The whole idea of liquidated damages is not to punish the party for breaching the contract. The idea of liquidated damages is to liquidate, to make certain, to try and assess the actual injury that the aggrieved party will suffer because of the breach. Here's the rule. The liquidated damages must be in a reasonable approximation of the injury the aggrieved party will suffer. They don't have to be exact, but this is what the parties have to be doing with the liquidated damage. They have to be approximating, estimating the injury the aggrieved party will suffer because of the breach. Can't be a penalty. And they must have some sort of reason for writing liquidated damages into the contract, right? The whole idea is that we're going to make something uncertain certain. So the damages that the aggrieved party will suffer have to either be difficult to assess or difficult to predict. That's what we're looking for. If the liquidated damages clause meets these requirements, then it is enforceable. If not, then it is most likely a penalty and the court will not enforce it. Now, that doesn't mean that the aggrieved party will not be entitled to damages. Of course, the aggrieved party will still be able to get general damages and consequential damages. If the court declares the liquidated damages clause unenforceable, then the aggrieved party simply can't rely on the liquidated damages clause to get her damages.